Imagine this. You've inherited a family home in another country, or you're removing abroad permanently and need to transfer ownership of your current property into a trust or to a family member in a different jurisdiction. It sounds like a simple paperwork exercise, right? You just sign a deed and mail it over. Unfortunately, that approach is a one-way ticket to a tangled web of legal disputes, massive tax bills, and potentially even having the transfer voided by a foreign court. Transferring property across international borders is arguably one of the most complex financial transactions an individual can undertake. It sits at the intersection of two different legal systems, two different tax regimes, and two different sets of bureaucratic rules. This isn't just a real estate transaction. It's an exercise in international law and tax treaty navigation. But when done correctly, it can secure your family's legacy, optimize your tax position, and facilitate a major life transition. In this guide, we will walk through the meticulous, step-by-step process that professionals use to legally and safely transfer property from one country to another. We'll move beyond the basics to uncover the hidden hurdles, the insider strategies for minimizing tax exposure, and the absolute necessity of building the right expert team. The entire process begins not with action, but with intensive research and professional engagement. You cannot afford to guess. Your very first step, before you sign anything or even make a formal decision, is to hire key professionals. A qualified real estate attorney in the country where the property is located, the situs country, and a cross-border tax advisor or accountant in your country of tax residency. These two experts must work in concert. The foreign attorney will guide you on local transfer laws, title issues, and required documentation. Your tax advisor will explain the implications in your home country. Will this trigger a capital gains tax event? Is it considered a gift subject to reporting? Trying to save money by skipping this step is the most common and costly mistake. Once your team is in place, the first substantive task is conducting impeccable due diligence on the property's current status. This goes far beyond a simple mortgage check. You must obtain an official, current title report or extract from the local land registry. This document must be certified and recent. It will confirm you are the legal owner, reveal any existing liens, mortgages, easements, or covenants on the property, and confirm its precise legal description. Any hidden lien from a contractor or a local tax authority will freeze the transfer instantly. Furthermore, you must research the foreign country's specific laws regarding ownership by non-residents. Some countries restrict foreign ownership entirely. Others allow it but impose higher transfer taxes or require special government approvals. Some require the formation of a local corporate entity to hold the property. Knowing these rules up front is non-negotiable. With a clean title and a clear understanding of the legal landscape, you must now define the nature of the transfer for both legal and tax purposes. There are three main types, each with vastly different procedures and consequences. First, a sale. This is a straightforward arm's-length transaction to a third party. The complexity here is managing a sale across borders, handling currency conversion, ensuring funds are transferred through proper banking channels to avoid money laundering flags, and complying with the tax withholding requirements of the property's country. For example, in the United States, the Foreign Investment in Real Property Tax Act FIRPTA requires a BIR to withhold 15% of the sales price from a foreign seller for tax purposes. Many countries have similar rules. Second, a gift. You are transferring ownership to a family member, like a child, for little or no monetary consideration. This seems simple, but it triggers gift tax reporting requirements in many countries. The United States, for instance, requires reporting of gifts to foreigners of over $100,000 annually. The recipient's country may also impose a gift or inheritance tax at the time of transfer. Third, an inheritance or post-death transfer. This is often the most complex as it involves the probate laws of the foreign country. Many countries have forced heirship laws that dictate who must inherit property, overriding your will. Navigating foreign probate requires a local attorney specializing in succession law. The key pro tip is to structure the transfer before it happens. For inheritance, this might mean placing the property in an international trust while you are alive to avoid foreign probate entirely. The structure determines the entire subsequent process. Now we reach the heart of the bureaucratic challenge: document preparation and legalization. The deed or transfer document prepared by your foreign attorney is just the start. For it to be recognized as valid in another country, for example, for your home country's tax authority to accept it as proof of disposition, it must often go through a process called legalization. This typically involves two steps. First, the document must be notarized by a local notary public in the property's country. Then, it often needs an apostille, which is a special certification under the Hague Apostille Convention that verifies the authenticity of the notary's signature and seal. Over 120 countries are members of this convention. If the recipient country is not a member, you may need a more arduous process called consular legalization, where the document is authenticated by the foreign ministry of the originating country and then by the consulate of the destination country. Every signature, every stamp, on every page of the transfer document and the supporting title report may need this treatment. This process can take weeks or months. A common fatal error is having a document notarized incorrectly or missing a required certification, rendering the entire transfer legally questionable. Concurrent with the legal paperwork is the tax analysis, which is a parallel and equally critical track. You must understand the tax implications in both countries to avoid brutal double taxation. In the country where the property is located, you will likely face a transfer tax like stamp duty, and if it's a sale, a capital gains tax on the profit. Your local attorney will calculate this. In your country of tax residency, you must report the transaction. If it's a sale, you likely owe capital gains tax on the profit when you file your annual return. Here's the insider secret. A double taxation treaty DTT between the two countries is your best friend. These treaties exist to prevent the same income from being taxed by both nations. Typically, the treaty will give the right to tax the capital gain to the country where the property is located. Your home country will then provide a foreign tax credit for the taxes you paid abroad, so you are not taxed twice on the same gain. But you must proactively claim this credit on your tax return. It is not automatic. For gifts or inheritances, you need to understand the estate and gift tax treaty, if one exists. Your cross-border tax advisor's primary job is to navigate this treaty landscape, file the necessary forms in both countries, and ensure you claim every credit and exemption you are entitled to. Failing to do this can mean paying tax twice on the same transaction. After the transfer is legally complete and taxes are paid, there are crucial final steps. First, ensure the transfer is properly recorded in the local land registry of the property's country. Your attorney should handle this, but get confirmation. This final recording is what legally changes ownership. Second, update your overall financial and estate plan. If you've sold the property, remove it from your asset list. If you've gifted it, ensure your will is updated to reflect that. Finally, retain all documentation indefinitely: the certified transfer deed, the apostille, proof of tax payments in both countries, and all correspondence with professionals. You will need this if you are ever audited or need to prove the legitimacy of the transfer years later. In conclusion, transferring property across countries is a high-stakes procedural marathon that demands respect for two sovereign legal systems. It is not a task for intuition or DIY shortcuts. The proven path involves assembling an expert team of local and international advisors conducting exhaustive due diligence on the property's title and local ownership laws, meticulously preparing and legalizing every document, and conducting a sophisticated tax analysis leveraging international treaties to prevent double taxation. By moving methodically with professional guidance at every turn, you can transform a potentially chaotic and costly ordeal into a managed, compliant, and successful transfer of your international asset. Disclaimer: I am not a lawyer, tax advisor, or licensed real estate professional. The information in this video is for educational and informational purposes only. It is not legal, tax, or financial advice. Laws and tax treaties vary dramatically by country and are subject to change. Transferring property internationally has serious legal and tax consequences. You must consult with qualified legal counsel in the jurisdiction where the property is located and a tax professional specializing in international law in your country of tax residence before initiating any transfer.